Mr. B,
Hello.
you've always said that a child will get status if they've been in the country for 7 years. So, how did our client yesterday get legal status for their whole family when the child had only spent 6 years in the UK?
Okay. You remember I always say every case depends on its own circumstances. And people think that this is just a wishy-washy statement. It's not. Now the rule is what? The rule says if a child has spent 7 years in the UK, was born in the UK and has spent 7 years living in the UK and is still under the age of 18, they will get indefinite leave. If the child came to the UK, was not born here and spent 7 years in the UK and still under the age of 18 and it is unreasonable for them to go back, then they will be granted status here. So what has happened here? This child has not completed 7 years, but there were special circumstances present in this case. So the child has special needs and there was a care program in there for the child, and it was proven by the documentation, and of course we did our arguments to show that it was unreasonable for that child to be removed from the UK. And because the child's care needs were so intense that the child should be allowed to stay here, the child could not obviously be separated from the family. So this family had overstayed because of the child's problems and could not go back, could not relocate the child. It was not in the best interest of the child to be relocated. So we fell upon Section 55 duty. Now, Section 55 of the Borders and Citizenship Act 2009, that says that the child's best interests need to be looked at. There are a list of factors that need to go through. So we went through all of that. We provided evidence of all of that, prepared the case like it's supposed to be prepared, and very happy to report that the whole family got their status, even though the child has not yet spent 7 years in the UK. That's how we got it.
So it really is case by cases.
It is case by case basis. And what I also want to say is that sometimes there are situations which do not fall within the rules, like this one did not fall within the rules. But when you look at the entirety of the circumstances, you look at the whole evidence that is connected to that case, you may be able to argue something. This is why I always say if somebody's overstayed in the UK, talk to us about your circumstances. Let's see if there is something special. Somebody's an overstayer, wants to stay in the UK with their partner, wants to stay with their somebody that they look after, somebody that they have a very close relationship with. All those things can be looked at. And if you've got the right kind of evidence for that, and if you can make the right kind of arguments, we can win those cases, which we've done here again.
I know you always tell your clients not to waste their life and sit in hiding with no status. Always better to put something in, especially when there are circumstances.
Always better to put in an application. I always say this because if you're in the country, you're spending that time where the Home Office doesn't even know you exist. What's the point of that?
It builds credibility once you actually introduce yourself to the Home Office.
Absolutely. And the simple thing is, again, that old joke. You got the guy sitting there praying, oh, please, I want to win the lottery. I want to win the lottery. And then lightning strikes and he hears the sound, or he hears the words, buy a ticket. That's the thing. If you do not put in an application, how are you meant to get your legal status? Nobody's going to come looking for you, knock on your door and say, there you go, we are going to give you status. So if somebody's been in the country for a long period of time, they haven't put in an application, they're just wasting their time. Because once they put in an application, at least something starts happening, something starts cooking, which is not going to be happening if you're just sitting there.
Completely agree.
Thank you very much.
Thank you. Bye.
Bye.